So what? See, when there is a contract between the agent and the principal, it does mean that agent is going to act for the best interest of the principal. Yes or no? He will be working for the principal. Yes or no? Hana,
Yes.
are you clear on this? So it could possible
Yes.
that when agent is acting for the principal, it could possible that agent might have to incur some of the cost from their pocket. Hana?
Yes.
But he's not incurring for himself. He's incurring for the principal. So he has a right to recover that. This is the next rule that we're going to learn about. Okay. The next thing that we're going to learn about कि अगर आप agent हो तो क्या क्या right है आपके पास. But whatever he's incurring, he will be getting the commission out of what the work, whatever the work he's performing up. Second thing, that whatever he's incurring for the in making the possibility of fulfilling or in making the getting the into the contact on the behalf of the principal. So whatever he's incurring will be recovered by the agent. Yes or no?
Yes.
Done. अभी क्या हो रहा है? For example, in emergency situation, when, for example, there is a no way of communication, when there is an emergency, and you haven't tested the property of the principal. In that case, you have to act in the best interest of the principal. Okay. So what you will do, you will try to either store that, you will try to keep it into the warehouse or safe, है ना? It could also possible that
Yes.
सेलिंग दैट इन्वेंट्री वुड बी द बेस्ट वन, बट ऑर्डर मिलना चाहिए. ऐसा नहीं है कि जो फ्रूट बेच रहा है, वॉट एवर द फ्रूट ही सोल्ड, what if those nature or those type or what I can say, those are the exactly fruit that need to be transferred. ऐसा भी तो हो सकता है ना? So it could possible that way. So ultimately, whatever you're doing, either first you have to communicate with the communication is the must thing. If the communication is not possible, in that case, you should not do the major things, or you should do everything which is irrelevant or which is why, which is basically the main objective of the principal. For example, if the principal is sending one type of the goods from another place, so ultimately he has to deliver some goods at the disposal, Hana? Where, at the destination, yes or no?
Yes.
So ultimate medium when he has hired you as a ship owner is that he wants the goods to be delivered. तो अगर आप बीच रास्ते में उन्हें बेच के चले जाओगे तो कोई सेंस बनता है क्या? नहीं बनता ना. मेन ऑब्जेक्टिव तो उसका यही है ना, टू गेट दोज गुड्स डिलीवर at the destination, whatever the condition, whatever the goods would like look like, huh? Okay, are you clear on this fact? Like कि
Yes.
जो भी cost incurred होती है that can be covered. second thing Second thing is that need to learn and go through the rules again, that principal property is interested to the person, an emergency make it necessary for the agent to act. Emergency should be there, impossible to communicate there after, because agency relationship will always start, एजेंसी बाय नेसेसिटी विल ऑलवेज स्टॉप व्हेन देयर इज एन पॉसिबिलिटी कि आपने प्रिंसिपल ने आपको कुछ प्रॉपर्टी दे दी है. फिर दीज टू थिंग्स विल हैपन एट अ सेम प्लेस. आफ्टर दिस योर रिएक्शन शुड बी दैट कि दैट वुड बी इन द बेस्ट इंटरेस्ट ऑफ द प्रिंसिपल. ओके. नाउ if we try to read the case which is there, Samvit, would you please give it a reading for this case?
In Sachs versus Monclos, M agreed to store SS furniture. Some considerable time later, M decided that he needed the storage space for his own use. He tried to contact S to get the furniture removed, but was unable to do so. So he sold the furniture. When S found out, he sued M for wrongfully disposing of the furniture. It was held that M was liable. His argument was that he had acted as an agent of necessity in disposing of the furniture was dismissed since he had sold it merely for his own convenience.
डिसमिस मीन कि कैंसिल कर देना और डिक्लेयर इनवैलिड. ओके, डन.
Okay, sir.
रॉन्गफुल डिस्पोजल मीन्स कि जो एम ने जो शेयर थे और जो गुड्स थे वो बेच दिए, है ना, वट एवर ही सोल्ड, उसे बेचना नहीं चाहिए था. ही शुड हैव कीप्ट them because ultimately if S has provided furniture to store them, so the ultimate responsibility of him to store them, है ना.
Yes.
But he has sold. Now S has made और sued means कि उसने केस लगा दिया M के ऊपर कि आपने wrongful disposing किया of the furniture. Okay, done.
Yes, sir.
Hmm. This was a decision of the court that it was held, means the decision of the court that M was liable. He was liable. He was proved liable because he his argument that he is acted. His argument means M ने ये बोला था अपने argument में कि उसने एजेंट ऑफ नेसेसिटी के तौर पे एक्ट किया था इन डिस्पोजिंग ऑफ द फर्नीचर. जो था वो कोर्ट ने कह दिया कि ये इनवैलिड पॉइंट है, आप ऐसे कैसे कर सकते हो. क्या ये बेस्ट इंटरेस्ट था कि आपने उनका वो बेच ही दिया. अगर उन्होंने बेचना ही था तो हाउ और व्हाई दे वुड बी कीपिंग द फर्नीचर एट योर प्लेस, है ना. If they would have to sell them, so they could have sold it by themselves. Huh? Done.
Yes.
Hmm. If you just try to read the second point, which is also there, the second case.
In Springer versus Great Western Railway, a consignment of fruit was found by the carrier to be going bad. The carrier sold the consignment locally instead of delivering it to its destination. It was held that the carrier was not an agent of necessity because he could have obtained new instructions from the owner of the fruit. He was therefore liable and damaged to the owner.
I want your explanation on this, and I will explain you. What is your take out of this?
Um, Over here, the the fruits were sold without uh, communicating to the owner of the fruit. So therefore,
Guys, you know what are the these words? Held, fact, liable, है ना. Damages means
yes,
monetary damages. Okay, this is one type of the resolution. Okay, dismissed means cancel or called invalid. Okay, then there is one more thing that is also known as an there is one more thing that is sued. Sued means ki you have bring a case on someone. Huh? Okay, okay. Or if it isn't sued
yes, sir.
by, it does mean you have been brought. There is a case which has been brought up against you. Okay,
Okay, sir.
done. Now with this keeping this keyword in mind, I want you to read or let me explain this. So basically, this was a case of the Springer and Great Western Railway. Abhi Great Western Railway is going to transport, है ना, the consignment of the fruit. Now, when they were transporting, there wasn't one person who was in carrier who was looking after the good or taking care. और उसने देखा कि जो मैं फ्रूट बेच रहा हूँ एक जगह से दूसरी जगह भेज रहा हूँ वो खराब हो गए, दे गॉट डैमेज्ड. ओके, तो उसने क्या सोचा कि यार, since I'm not able to connect with the owner, since I'm not able to connect with the principal or goods getting damaged, so why I should not sell them right now? I should stop the train here and there and get rid of this goods. So is this the best interest it is the best interest of the it is in the best interest of the principal or not?
No.
हाँ, because ultimately what is the expectation of the principal? अगर उसने सुबह को सामान भेजा तो शाम को एक्सपेक्ट कर रहा होगा कि उसका सामान डिलीवर हो जाएगा एट द डेस्टिनेशन, है ना.
Yes.
बट व्हाट ही इज गेटिंग टू नो कि उसका सामान था वो बेच दिया. ओके okay? और फिर जो कैरियर था उसने कहा, उसने क्लेम किया कि बिकॉज इट वाज हेल्ड, वो क्लेम कर रहा था कि मैं एजेंट बाय नेसेसिटी था एंड व्हाटएवर आई हैव डन इट वाज इन द बेस्ट इंटरेस्ट ऑफ द it was in the best interest of principal now, but the court will decide whether it was in the best interest or not, है ना. And when the
Yes.
court come to realize, they basically declare that it was held that the carrier was not an agent of the necessity because he would have obtained the new instruction from the owner of the fruit whether they should sold them or whether the damaged good need to be delivered. हाँ, क्या हो सकता है कि damaged good अपन deliver कर रहे हो? It could also be possible. हाँ. So he was therefore liable in the damages to the owner. Is it okay?
Yes.
Hello. Are we clear on this now?
Yes.
So
Yes,
now
sir.
we'll proceed with the point which is in rectification. I've been very vocal about from the starting of the lecture that ki agar agent is working or going beyond or exceeding their authority, so what will happen? There is a possibility of rectification which can be done by the principal or which cannot be. Basically, it is the choice of the principal whether they want to rectify it or not. Huh? But if they're going to rectify, so the liability will transfer from the agent to the principal. Okay. But if that is not that if that is not going to rectified by the principal, in that case, the liability will remain with the agent. Is it okay?
Yes.
If the properly appointed agent exceed his authority or a person having no authority purport to act as an agent, the principal has no liability on the contract unless the principal rectified with the contract. So have you understood this line? कि अगर एजेंट ऐसे काम करता है कि उसके पास कोई ऑथोरिटी नहीं है स्टिल ही इज वर्किंग और ही इज वर्किंग बियॉन्ड हिज ऑथोरिटी in both of the cases the principal will not liable until and unless he rectifies the contact. If he rectifies the contact, in that case, he's taking okay, whatever he has done as my agent, I will be, or whatever he has done. Now I expect or I accept him as an agent. In that case, the principal is claiming or principal is openly stating that I claim or I take full responsibility of whatever he has done. Okay. Done.
Yes, sir.
For example, there is a home. Okay. This was in home of the owner B. Okay. Agent was there and agent was not in touch with the agent. Agent was not touching with the owner, but he knew that this house was on the sale. Now he find up some of the customer to buy the house. Okay. Hello. And make a contract
Yes.
with them that I will be selling this house for this precise or whatever the precise amount that he was advertised to do. Because ultimately when there is a possibility that because in the market you will see that if some goods need to be sold or when some good need to be or when they're in the market, so the possibility that what is the price that going to be charged or the price the seller is willing to sell will always be out in the market. Huh? So if the owner want to sell a house, some of the agent might know what is the price he's going to charge. It could possible that agent might know the owner, they might not know the owner. But if the agent is getting into the contact with the buyer to sell the house, now it will be on the owners whether they want to rectify it or not. Okay. But rectification can only be done when the principal has some right. Principal do meet some of the characteristic. Okay. Now, what are these characteristics I'm talking about? That the principal should be the right or the legal owner of that house. Yes or no? Huh?
Yes.
It does mean that they should have the contractual capacity to make the contact. Yes or no? Done. And have been in existence both when the contact was made or at the date of the rectification. Is that okay? He should be there when the contact was made. ऐसा ना हो कि he should not be there when the contact was not there, because ultimately he should not need to be presented when there is an agent and the buyer is making a negotiation, right? But he should be there. ऐसा नहीं हो कि he is not living there or what blah blah. Huh? Even it could possible that he is not living in his home because it might not be the primary home. What do present होना चाहिए at that place? हाँ, कहाँ पे in this world? Okay, है ना? Or at the date of the rectification. Is it okay? Done.
Yes, sir.
And it can be identified when the contact is made. It can be identified that the principal is can be or the principal is basically can is the right owner of the house. And be aware of the all the material fact. ऐसा उसे पता होना चाहिए कि what he is doing. Okay. है ना? उसे लगना चाहिए, उसे इस चीज का सेंस होना चाहिए कि एजेंट जो डील करी है बायर्स के साथ, इट्स ऑफ द हाउस। इज ही इवन रेडी टू सेल द हाउस और नॉट, है ना? Clearly signifies his intention to rectify the whole context within the reasonable time. ऐसा ना हो कि वो unreasonable time में आ रहा है. What is a reasonable time? Reasonable time can vary according to different cases, but it should be done into the reasonable time. और अगर unreasonable चीज कुछ हो रही होगी तो you can easily find out in the question, ना? But it should be done within the reasonable time. Okay, it should not be that key bar is now there and you are approaching or saying or say rectifying the contact. There is a contact which is made by the agent and the agent and the buyer, but you are rectifying it after the 6 years or 1 year or 6 months. Huh? This is not the reasonable time. Huh? 1 month, 2 month can be. Okay, done.
Yes, sir.
Yes, sir.
Now note that void and illegal contact cannot be rectified. Done. And if the illegal contact is made on the by the agent with the whatever the party, so why the owner itself would be doing the illegal contact? Huh? He would not be indulging or entertaining this sort of the things. Huh? So what I mean to convey, the void and the illegal contact cannot be rectified. Is it okay? Are we clear on this? Now we will see some of the case study and that will further help us in getting a better understanding of the thing. Is it okay? There's a case that is known as Kellner and Baxter. Fact means what was the reason or what was the main material fact of the case. The promoter of the company entered into the contract on behalf of the company before it was incorporated. So promoter are basically the few initial co-founders or the co-partners or the co-founders who basically look around building up the company from the scratch, right? These are known as the promoters. Promoters of the company entered into the contract on the behalf of the company before it was incorporated, to purchase some property. Okay, done. Hello.
Yes.
The other party was not paid. Wow. So what I mean to say that there isn't company is a separate legal entity. You know this or not?
Yes.
But when it would become the separate legal entity when it is incorporated, now? Yes or no?
Yes,
When
sir.
it is
Yes,
not
sir.
incorporated at all, how we can when there is no existence of the company, so how you can claim that the contact is made on the behalf of the company and the party, huh? Hana? So the promoters are who are there? They are basically the agent. Huh? They're making a contact on the behalf of the company who will be the principal. Okay, done.
Yes, sir.
Does the company exist when there was a contact which is made by the agent? Does the company exist or not? Tell me.
No.
Hmm. There is one point, if you can guys recall this or just go through with this again. Was the principal existed? This require P2? No. So this is a second point. Huh? So in that case, rectification can be possible or not? It could be possible or not?
No, sir.
Done. So what was the decision? As the company did not exist at the time of the contract was made, the company could not rectify the contract. The promoter were personally liable to the seller. Is that okay? Clear? Siddhant, Samvid, brother. All okay?
Yes.
All going good? See, I'm little bad in pronouncing these things, right? So what is the company name? You just pronounce it. I think you both are good in this. What is the fact? A principal in effect said to the third party that I don't know what my agent has agreed to do, but I must support him. A principal in effect said to the third party, मुझे नहीं पता कि मेरे what my agent has agreed to do so, but I will support him. हाँ? अभी Abhi, it could give rise to many of the possibility. Like there can be the possibility that the agent is getting into the illegal contact. Huh? If it is an illegal contact, could it be possible to rectify it? No, no. If the agent is getting into the illegal contact, it would not be possible to rectify it. Yes or no? I'm talking about this line. What is the decision that the principal had rectified? Although he did not know that the agent has exceeded his authority, he had agreed to take the risk. Okay? Who has agreed? The principal. There is one more thing that comes as an estoppel. This arises where P implies that A is is agent even though he is not agent. So what happens is that, for example, this is basically known as an agent by estoppel. There is a party, there is a principal party, there is an agent. There is a no contact between A and P, that these are there is an agency relationship between the two. But if P claims that A is my agent, even though he is not, when in that case, P will be liable. Okay. Done? Hello? Done?
No, can you repeat the meaning of estoppel?
Hmm. Estoppel means ki what you sow to the world will mean the same thing. Okay. Suppose me, I'm going out with some other individual to a market, huh? Or I'm having a meeting and then I'm going out with some other individual. Huh? Now the other person who would be seeing will be consider that he's my friend. Huh? Huh? So through my conduct, or if I say this, that he is my friend, through implied, Hana, express or implied. Implied means whenever someone would see or whenever we meeting, so he probably be thinking that he works with a promoter. So whatever you show will mean to the same thing. It will be the agent by staple. For example, if P implies that A is his agent, even though he's not an agent, okay? There is a no contract between the principal and agent, that agent is my agent is my, basically there's an agency relationship between both of the two. But if the agent, if the principal is acting like that, he is accepting the other individual as an agent, in that case the principal will be liable with all of the activities that A will be doing. Okay. Huh? I think I should give it a example, a good example over here. So I think it would become easier for us. So there are the five types of the agency relationship: express, implied, necessity, estoppel, rectification. These are the four things, and rectification. Huh? This is a agency by rectification. Okay. Hello.
Yes.
Huh.
Yes, sir.
Abhi, they are the two peoples, right? People X, Y, Z and A, B, C. Okay. Now the X, Y, Z is basically the owner. Okay. He is an employee. Okay. But because there wasn't good bonding between the two, so whenever they go out, they just claim or they just go outside to the market. Okay. Hello. Whenever they go to the client meeting, they just go together. And every time XYZ is who is the owner, who is meeting with the client, always claim that he is my co-founder, even though he's an employee, the basic employee, huh? Even intern, we can call this as an intern. He claimed that he's my intern. He claims basically that he's my co-founder, huh? Or represent him himself as an agent, okay? Because if he's an owner, so he's a shareholder, yes or no? At the place when he's an intern, but he's representing that he's a co-partner or the managing director. In that case, if he's a director, so it becomes the agent. So whenever the owner who's claiming that the employee or the intern is an agent, so it will deemed the same thing what you are showing to the world. If employee or that individual do something wrong with this owner, or try to make or try to take the client, or if he just try to do anything then this owner will bound by the actions of this intern and employee. Is that okay? Because he has accepted him as an employee into the market, and whenever he is going to make, whenever the agent or whenever the employee we are talking about, whenever he is going to make a contact on the behalf of the owner or the company, in that case he will be liable to that, even though he's not in a position to make the contact, but he would be considered that he's making the power, because ultimately the other party would be thinking that okay, he's the probably the managing director, huh? He's doing that out of the capacity of his position. And I know this from because the owner has itself said it that he is agent hai. Okay, are we clear on this?
Yes, sir.
Yes, sir.
Now this is one of the question which you please help, would you please help me with this?
B.
Samvit? Samvit, would you please answer which one you would be selecting?
B.
Why?
Because it is a case of ratification.
Done. Please, would you please try this? Samvit, you will be answering this question. If you guys remember the 4 or 5 pointers, in that case, you will always be canceling this B option, है ना? So this is the way, basically the methodology of elimination. कि पहले चारों ऑप्शन में से वो चीज हटा दो जिसके लिए आप प्रीटी श्योर हो, तो ये तो कभी हो ही नहीं सकता, है ना? हेलो, है ना?
Option A.
गुड. Siddhant, are we go? Can we move ahead? Huh? I think you were done with this question. Huh? You have done this.
Yes, sir.
All right. Now we'll look around what is an authority which is there. Huh? Okay. So what is your take on this word itself? Like, what do you understand by the authority? I do not need a definition. I just need to know what is your take on this.
Authority is like the power that is given to an agent. So it determines what actions he can and cannot take.
Hmm. Along with the authority, there is a responsibility that comes with. Huh? And this is basically the central issue in the concept of the agency. Is it okay? Done? So the authority of an agent is a central issue in the concept of the agency. Why it isn't central authority? Because everything, whatever the link between the agent and the link between the agent and the principal, whatever it is happening between the two, is what? Is nothing but the authority. Yeah? The authority which is flowing from the principal to the agent. Okay? Okay? That's why it is a central issue. The question of the authority deals with the power and the duties that the agent has on the behalf of the principal, and it will determine when and for which act the principal will be liable and will have to indemnify the agent. If the agent exceeds his power, the principal may still be liable to the third party, but he may have the right against the agent for the breach of the contract. Okay? Done? Hello?
Yes, sir.
अभी मैं आपसे एक चीज पूछना चाहता हूँ बिकॉज अल्टीमेटली देयर इज एन कॉन्टेक्ट. फॉर एग्जांपल अभी अपन एक्सप्रेसली बात करते हैं कि देयर इज एन एक्सप्रेसली एग्रीमेंट बिटवीन द एजेंट एंड द प्रिंसिपल. हाँ, तो इट वाज रिटन और ओरली कम्युनिकेटेड कि आपकी ऑथोरिटी ये है. अगर आप इस ऑथोरिटी को एक्सेप्ट करते हो तो हैज एन एजेंट यूर ब्रीचिंग योर द कॉन्टेक्ट. हाँ, द कॉन्टेक्ट विच इज बिटवीन अस. हाँ, यस और नो? है ना?
Yes, sir.
So it could possible that you have made a contact with a third party, and as in principle, I might have to rectify that. Okay? Because the contact has been made. But I can claim the breach of damages or the breach of the contract from the agent. Why? Because the agent was given the authority and he's acted beyond that. So he has breached something. Huh? He has breached the contract, the agreement between that की आपकी authority है और आप उससे आगे काम कर रहे हो. So this is something not an acceptable thing. So in that case, he can claim or would be having a right against the agent for the breach of the contract. Is that okay? Now we will learn about the type of authority of an agent. This will go the same way. Implied authority, apparent authority. Okay, implied authority. You know what is an implied thing in implied agency law? The same thing. Implied authority कि आप अगर agent बन गए हो और आप principal हो तो what is going to be the basic duty of yours कि आपको पता है कि आप you have a right to make the contact on the behalf of the principal. I will just quickly get it done because this is something the same meaning we are going again and again. Is when the third party assume that by the virtue of the person positions status in the company or relations with the principal makes him a valid agent. Example, a supplier may assume that a factory manager is an agent of the factory owners and accept an order placed by the manager on the behalf of the factory owners, right? This is because any factory manager would have the implied authority to order the good for the factory. Okay? Hello? Because the factory manager who is in the position to look around the factory, so he is the right to order the goods for the factory. So this is what the implied authority. Implied authority means that comes from within the position. Okay? Hello? That comes within the position. Apparent authority means is when the action of the previous dealing from a person gives the appearance that he and she is an agent of the principal. For example, if Sekhar frequently buy tennis ball for Brat, which are later paid for by the Virat, the seller of the tennis ball will assume that Sekhar is an agent of the Virat. Huh? So whatever how you're making yourself appearance into the market might give you the right or might give you the authority. So that will be known as an apparent authority. और there was this one more thing जो स्टेपल वाला कॉन्सेप्ट है ना कि how you would show to the world, how you would look to the world, वो स्टेपल लॉ तो वहां पे है ही है. The apparent authority is more of the same thing that has been given through the stepel, huh? But there is a slight difference, so better to remember them by the word or the definition. Okay, is it okay? Then you have an express actual authority. It does mean it is a form of authority given to the agent directly by the principal. Implied actual authority, an agent has implied authority to do so, which are reasonably accidental to the performance of an expressly authorized act, has not been expressly prohibited by P. P ने अगर किसी चीज के लिए रोका नहीं है तो it does mean कि उसका scope है. An agent occupying that position would usually have authority to do so. This is the case study which we're gonna look around the below. But if you talk about the apparent, in that case, Such authority arise where PA is held out by the P as an having authority. वही वाली बात कि P is still now making it appearance that कि A is my agent. In that case, if whatever the A is doing will be considered, other party will be assuming that A is an agent of the P. Okay. The representation by P may arise from the previous dealing, allowing A to make the contact in the past is a representation that A is an authority to continue to do so in the future. However, a third party cannot rely on the apparent authority when he knows the lack of the actual authority. Okay. अगर यहाँ पे दो चीजें, अगर अगर थर्ड पार्टी को पता है कि दिस इज नॉट द एक्चुअल ऑथोरिटी, सो दे विल नॉट गोना रिलाई. अगर थर्ड पार्टी को डाउट है कि दिस इज वेदर दिस इज एन एक्चुअल ऑथोरिटी और अपेरेंट ऑथोरिटी, इन दैट केस दे कैन रिलाई. ओके. बट इफ समवन इज डूइंग द थिंग्स इन द प्रीवियस, तो उन्हें लगेगा कि ही हैज बीन द वन जो कांटेक्ट कर रहा है ना. देयर इज वन एग्जांपल आई वुड लाइक टू टेक ओवर हियर. फॉर एग्जांपल, दे आर द पार्टनर्स इन द फर्म. दे इज इन पार्टनरशिप फर्म. हाँ. ओके. In the partnership, there's in four partners, right? One partner left the company, and that partner was the one who basically deal with all the client. Now this partner go to the previous client. In that case, they will assume that that partner is also dealing with that existing firm partnership or not, है ना? Even though he's not dealing currently, but he's dealing. So why it would be the case? Because it is because of the appearance. Huh? What he has done in the past might let other party assume that he's still doing the same thing. Okay. Until and unless he specifically say that I'm doing this. Okay. So the other party who would be there probably be thinking that he's the one who is on the actual authority, because ultimately when he was in the partnership firm, so he was dealing with the issues as their owner or as a mean of the actual authority. Is it okay? Hello, are you okay with this? Hello guys, are you there?
Yes, sir.
Are we going good? So how many
Yes.
pages are there? So they are like 72 pages. We just need to wrap up this. So what is in fact? The new owners of the business continue to employ the original owner as a manager. Huh? In agency agreement, the new owner orders the agent not to buy certain items, including cigar. What they are doing, that agency agreement, the new owners था उसे order किया था गया था कि agent को order the agent will not buy certain items, such as including cigars. The manager still brought the cigars from the third party. The owner then refused to pay the cigars, right? Now, the decision of the court was this, that the purchase of cigar was within the usual authority of the manager of the hotel. कि hotel का manager है तो वो कर सकता है. The contract was binding on the owners. If the limitation on the usual authority is going to be effective, then it must be communicated to the third party before any contract is made. अगर आपको ये बात होनी थी तो जो ओनर था उसे पहले ही स्पेसिफिकली बोल देना थर्ड पार्टी को कि ही इज नॉट माय ओनर, ही इज नॉट बेसिकली हैविंग द अथॉरिटी. ओके, है ना? बिकॉज जो भी पावर आ रही है ना उसकी पोजीशन से, सो ही वुड बी डूइंग दैट सेम थिंग. इफ आई टॉक अबाउट द डिस्कशन, सो द डिसीजन कुड नॉट बी बेस्ड ऑन द अपरेंट अथॉरिटी because the principle is disclosed under the doctrine. The principal is held liable for the action by the agent that are expressly forbidden, but the case limit a person to action of the agent that are reasonable under the circumstances, and in that cases the owner might going to claim or might going to go for the case for the breach of the contract with the hotel manager. Okay, because ultimately he is very specifically mentioned कि आप ये चीज नहीं करोगे, but still he is doing that, so he is going beyond the authority. थर्ड पार्टी के लिए तो पार्टनर लायबल है, जो प्रिंसिपल है वो लायबल है, बट अदर देन दैट यू विल सी और यू विल ऑब्जर्व कि जो that the party, or sorry, the agent that is there, he might be claimed by the principal. Is it okay? Hello. So I think we are less than a 1 minute, and I want you to join the class again. We will not be taking a break. I'm so sorry for that. Okay. We'll take a break after this session. Okay.